This is the verified complaint and answer. The nature of the case. This is an excessive force action brought by plaintiff Gabriel Torres against the defendant, the Arcadia Police Department, or APD, to remedy violations of the Due Process Clause of the 14th Amendment to the United States Constitution, pursuant to 42 Utopia Code 1983, for the unprovoked use of freeze P pepper spray by defendant's agent, Officer Max Carter. The unjustified use of said pepper spray was the direct result of the defendant's long-standing policy, practice, and custom of permitting its agents to use unreasonable and excessive force when apprehending students of El Dorado County schools. In the defendant's verified answer, number 1, the allegations contained in paragraph 1 of the complaint do not appear to require a response. To the extent that a response is required, defendant denies these allegations. Paragraph 2 of the complaint. Plaintiff Torres is a minor born on September 12, 1999 in Saipan, Northern Mariana Islands. At age 13, he traveled to Arcadia, Utopia to live with his relative, Nikki Mendoza, and attend high school. Defendant's answer to paragraph 2. Defendant lacks information sufficient to form a belief as to the truth or falsity of the allegation in paragraph 2 of the complaint, and thus it is denied. Paragraph 3 of the complaint. Defendant, Arcadia Police Department, is a department, agency, bureau, and or subdivision of the state of Utopia. Defendant is a person for all purposes of enforcement of the rights guaranteed under 42 U.C. 1983 and the 14th Amendment to the United States Constitution. Defendant's answer, paragraph 3, is admitted. Paragraph 4 of the complaint. This court has jurisdiction, subject matter jurisdiction, because this action is brought under the Utopia Civil Code. Defendant's answer, paragraph 4, is admitted. Paragraph 5 of the complaint. This court has personal jurisdiction over defendant because the central office of defendant is within the district and acts and omissions forming the basis for this complaint occurred in Utopia. Defendant's answer, paragraph 5 of the complaint. Defendant admits that defendant's central offices are within this district and otherwise denies the allegations contained in paragraph 5 of the complaint. Paragraph 6 of the complaint. Venue is properly placed in this district because the central office of defendant is within this district. The event giving rise to the claim arose in this district, and records relevant to the practices complained of herein are located in the district. Defendant's answer to paragraph 6. Upon information and belief, admitted. Paragraph 7 of the complaint. In the aggregate, plaintiff's claims exceed $25,000 exclusive of interest and costs, and therefore this court has original jurisdiction. Defendant's answer to paragraph 7. Upon information and belief, it is admitted. Paragraph 8 of the complaint. On October 13, 2015, defendant APD employed Officer Max Carter as a sworn peace officer in Arcadia, Utopia. The defendant answered. Paragraph 8 is admitted. Paragraph 9 of the complaint. On October 13, 2015, Officer Max Carter was assigned to work as a school resource officer, or SRO, at Arcadia High School in the El Dorado County School District. Defendant's answer to paragraph 9 is denied. Paragraph 10 of the complaint. During second period at approximately 9:35 a.m., Officer Carter abruptly entered the classroom in which Gabriel Torres was peacefully attending class. Defendant answered, denied. Paragraph 11 of the complaint. Without provocation, Officer Carter, in a threatening manner, ordered Gabriel to hand over his backpack and accompany Officer Carter to the principal's office. Defendant's answer to paragraph 11 of the complaint is denied. Paragraph 12 of the complaint. Confused and frightened, Gabriel reached for his backpack only to be sprayed with pepper spray by Officer Carter. Denied. Paragraph 13 of the complaint. The pepper spray caused great pain to Gabriel Torres and he fell to the floor. Defendant answered, denied. Paragraph 13 of the complaint. Paragraph 14 of the complaint. Officer Carter did not offer to assist Gabriel. Instead, he handcuffed Gabriel and roughly dragged him to the principal's office. Defendant answered, paragraph 14 of the complaint, denied. Paragraph 15 of the complaint. At no point was Gabriel given a chance to wash out his eyes, change his clothes, or do any of the other steps recommended by the manufacturer or to decontaminate from the pepper spray. Paragraph 15 of the defendant's answer. Defendant lacks information sufficient to form a belief as to the truth or falsity of the allegation in paragraph 15 of the complaint, and thus it is denied. Paragraph 16 of the complaint. An hour later, Gabriel was transported to the police station. At no point during this time was Gabriel's guardian, Nikki Mendoza, contacted or apprised of what had occurred. Defendant's answer to number 16 in the complaint. Defendant lacks information sufficient to form a belief as to the truth or falsity of the allegation in paragraph 16 of the complaint, and thus it is denied. Paragraph 17 of the complaint. At the police station, Gabriel was handcuffed in a room and left alone. At no point was Gabriel given a chance to wash out his eyes, change his clothes, or do any other of the other steps recommended by the manufacturer to decontaminate from the pepper spray. In defendant's answer to number 17, it is admitted. Paragraph 18 of the complaint. At the station, it was determined that Gabriel's pack contained a 3D non-functional model of a gun that posed no threat to anyone. Defendant's answer to paragraph 18 is admitted. Paragraph 19 of the complaint. Gabriel's guardian was finally contacted and Gabriel was released into his guardian's care. Defendant's answer to paragraph 19 is admitted. Paragraph 20 of the complaint. Gabriel was so traumatized by these events that he never returned to Arcadia High School. Instead, he returned to his home in the Northern Mariana Islands on October 27, 2015, thereby losing the substantial education benefit he had received while attending Arcadia High School. Defendant's answer to paragraph 20 of the complaint is denied. Paragraph 21 of the complaint. Under the caption, cause of action, violation of due process due to the defendant's policies, practices, or customs that promote violations of constitutional rights. Paragraph 21. Plaintiff repeats and realleges paragraphs 1 through 20 as if fully set forth herein. Defendant's answer. Defendant's response to paragraphs 1 through 20 are incorporated herein by reference. Paragraph number 22 of the complaint. The Due Process Clause of the 14th Amendment to the United States Constitution provides that no state shall deprive any person of life, liberty, or property without due process of law under the United States Constitution. Such violations are actionable pursuant to 42 M.C. 1983. The defendant's response to paragraph 22 is admitted. Paragraph 23 of the complaint. Defendant APD exhibits a policy, practice, or custom of inadequately training, supervising, and disciplining law enforcement officers who use unreasonable force when acting as SROs. The defendant's answer to paragraph 23 is denied. Paragraph 24 of the complaint. Although defendant has written policies concerning the use of force in school environments and the treatment of officers who use unreasonable force, these policies are superseded by the predominant, overriding, and long-standing policy, practice, or custom of defendant knowingly, willfully, and deliberately A. Overlooking or ignoring incidents of unreasonable use of force by APD officers. B. Allowing its officers to actively promote the use of unreasonable force. C. Refusing to intervene or take any preventative and/or precautionary measures to eliminate or even stem the use of unreasonable force by SROs. D, failing to discipline or impose any sanctions on its officers who have used unreasonable force, including those who have done so repeatedly or even habitually. The defendant's answer to number 24 of the complaint is denied. Number 25, paragraph number 25 of the complaint. The foregoing conduct violates the Due Process Clause of the 14th Amendment of the United States Constitution pursuant to 42 U.C. 1983. The defendant's response to paragraph 25 is denied. Paragraph 26 of the complaint. On 6 occasions prior to October 13, 2015, complaints alleging use of unreasonable force by Officer Carter were filed with the APD, 5 of them involving students at Arcadia High School. Defendant's answer to paragraph 26 of the complaint is denied. Paragraph number 27 of the complaint. Despite receiving the above notice, defendant did not adequately investigate or discipline Officer Carter during Carter's employment with the APD and thus failed to take necessary and reasonable measures to protect the public, including Plaintiff Torres, from Officer Carter. Defendant's answer to paragraph 27 is denied. Paragraph 28 of the complaint. Defendant's decision to permit Officer Carter to serve as a school resource officer despite receiving the above notice is consistent with its policy, practice, and custom of failing to properly investigate and discipline officers that utilize unreasonable force. Defendant's answer to paragraph number 28 is denied. Paragraph number 29 of the complaint. During the events in question on October 13, 2015, Officer Carter was acting under color of law as a duly authorized agent of the APD. Defendant's answer to paragraph 29 of the complaint is denied. Paragraph 30 of the complaint. When Officer Carter sprayed Gabriel Torres with the freeze pea pepper spray, Torres was unarmed and defenseless and made no furtive or threatening moves or gestures whatsoever. Defendant's answer to paragraph 30 of the complaint is denied. Paragraph 31 of the complaint. At no time during the foregoing wrongful action were Officer Carter or others in imminent, serious, grave, or life-threatening danger, and at no time did the circumstances, including plaintiff's actions, appearance, and demeanor, give rise to a reasonable perception or fear of imminent, serious, grave, or life-threatening danger to Officer Carter or others. Defendant's answer to paragraph 31 of the complaint is denied. Paragraph 32 of the complaint. Through his actions, Officer Carter unjustifiably, directly, and proximately caused harm to Torres, including but not limited to severe pain and suffering and mental anguish, such that Torres believed it necessary to leave Utopia and return to the Northern Mariana Islands, thereby severely damaging Torres' future educational opportunities and career opportunities. Defendant's answer to paragraph 32 of the complaint is denied. Paragraph 33 of the complaint. As a result of the foregoing, Officer Carter's actions were an unjustifiable and unreasonable violation of Torres' right to due process of law under the 14th Amendment of the United States Constitution pursuant to 42 U.C. 1983. Defendant's answer to paragraph 33 of the complaint is denied. Paragraph 34 of the complaint. Because of the APD's violation of Torres' constitutional rights, Torres has suffered damages and will in the future suffer damages as described in the foregoing paragraphs incorporated herein. Paragraph 34 of defendant's answer is denied. The prayer for relief in the complaint. Wherefore, plaintiff respectfully requests this court to award compensatory damages for the medical bills and associated costs, pain and suffering, emotional distress, loss of dignity, and damage to reputation and livelihood endured by plaintiff in amounts that are fair, just, and reasonable to be determined at trial. Award plaintiff all costs of this action and reasonable attorney's fees, and grant plaintiff such other and further relief as this court deems just and proper, including punitive damages and injunctive and declaratory relief, as may be required in the interest of justice. Dated February 9th, 2016. Respectfully submitted by Wingate, Williams, and Schmidley, attorneys for plaintiff. Defendant's answer. Wherefore, having fully answered the complaint of the plaintiff, defendants pray for a trial by jury, and that plaintiff's complaint be dismissed, that plaintiff recover nothing, and that plaintiff be charged with the costs and disbursements of this action, and for such other relief as this court may deem just and proper. Dated March 9th, 2016. Respectfully submitted by Bunce, Etzminger, and Kleinschmidt, attorneys for defendant.